Good day, everybody. My name is Zazabaloi. I'm the Communications Officer at Surfast. Welcome to today's webinar. I'm going to give you a few house rules before I hand over to Anza so that she can introduce our speaker of the day. A few rules to be followed. Please note that all opinions and statements are those of the individual making the presentation and not necessarily the opinion or view of Surfast. The webinar is being recorded and will be available on the Surfast website within 7 days. For best viewing of today's presentation material, please click on the maximize in the upper right corner of the slide window, then restore to return to normal view. Please turn off other applications that require internet connection to avoid slow transmission and blurry vision. Audio is transmitted over the computer, so please have your speakers or headphones on and the volume turned up in order to hear. We do not have a telephone connection. Questions should be submitted to the presenter during the presentation using your question, the question section on the right side of the screen. Click the drop-down arrow, type your question, and then click submit. Questions will be answered at the end of today's presentation. When typing your questions, please refrain from using acronyms to allow the moderator to easily read your questions out. With that, thank you very much, and I'm handing over to Anza to introduce today's speaker. Anza, over to you.
Good, thank you, Tsetse. Good day, everyone, and welcome to our Surfast webinar this afternoon. My name is Anza Bester. I'm from the Surfast Cape branch, and I'm welcoming you from a very cold and wet Cape Town today. I'm sure our speaker of today don't need a lot of introduction. So Janusz, thank you for doing this for us again today. If I can just say two or three things quickly about Janusz, not to make the introduction too long. So Janusz has 2 degrees, one in chemical engineering from the University of Pretoria, and he's also have a law degree also from UNISA. And then he's a registered attorney and a professional engineer. So thank you for making time for us, Janusz. I know you're a busy man, so we're really looking forward to this interesting topic and understanding how we can be more compliant to the legal standards and regulations. Thank you. Over to you.
Thank you very much. I'm going to turn off my camera now, and then we can just carry on with the presentation. Okay. Going to fold that little go to webinar screen away. So just so you understand, while we're presenting, I can't actually see any questions because the little go to webinar screen is folded away. So I don't see if questions are coming in. So if there are questions, I hope that either Anza or somebody will just alert me to them. All right, so today's presentation is actually very timeless, and it's a very interesting topic, the legal standing and consequences of disobeying legal standards and regulations. Now, why I'm saying it's very timeless, during this lockdown period, there have been a number of very interesting court cases that have been decided which relate to the topic of food law, where courts have made findings which will be very surprising to people that are in the food industry. Also, there's been quite an abrupt change with the way that the Department of Agriculture is dealing with industry when there are non-compliances. And likewise, similar situations have started to come up with port health on imported products. Now, it could just be coincidental. It could also be that people are sitting at home and actually now the regulatory authorities have time to think through what is industry doing in terms of compliance. Now, one of the reasons why I said this may be very surprising to people in industry is that for all the time that I've been involved in food law, the situation has been that if you're not compliant, you just pick up the phone, you phone someone and you say, oh, gee, I'm really sorry. You know, it was just a mistake. You know, we have so much product in stock and it'll be such a waste. Let us sell it out and we'll change that for next time. Next time our product will be compliant. And quite frankly, up until 2019, that story normally worked. People were forgiven, they were given permission to change things, and therefore it was never taken all that seriously. But things have changed, and I think are going to change even more. Right, so let's go straight into it. So in South Africa, just to refresh your memory, there's no single regulatory authority when it comes to food. We have vertical and horizontal fragmentation. There's a Department of Health that deals with certain issues, and those could be enforced by the environmental health practitioners at municipal level. We have the Department of Agriculture, nowadays called DALRAD. They have an inspectorate, but more importantly these days, it's the assignees that will come out and inspect you. Why that is important is that there are a lot more assignees, so your chances of being inspected are much, much higher because there are now enough of them. Then we have the Department of Trade and Industry, and that includes all aspects of the Consumer Protection Act, and very importantly, the National Regulator for Compulsory Standards. And then also we have self-regulation, which includes, for example, the Consumer Goods and Services Ombudsman. So as you can see, there isn't one place where you can go to ensure that you are compliant with everything. Depending on the product you sell, you could fall under health, agriculture, DTI, and even more regulatory authorities. So what are the current issues that I wanted to talk about today? The first one is non-compliant labeling of imports. And I'm not going to go into what the requirements are. I just want to discuss the consequences of having non-compliant imports. The hygiene regulations, so-called R638, we've got the enforcement or lack thereof previously of various regulations and standards, and the effect thereon by now having assignees, of whom there are plenty and who are motivated to go out and do inspections because they are paid per inspection, and environmental health practitioners who go out and now have more training, are better qualified, and are able to better enforce the regulations that fall under them. There's also a very interesting thing that's happened, is there's been a cooperation of EHPs with the National Consumer Commission, where they have gone to businesses as a unit, the National Consumer Commission with the environmental health practitioner, for example, to deal with expired foodstuffs. So taking those into account, we need to understand the consequences of non-compliance, and I've got some court cases I'm going to go through and refer you to. One of those issues is the private legal action for enforcement against competitors. You may wonder what that means. Well, if you have a competitor, you have spent a lot of time and effort and money to make sure you comply with the law. Your competitor has chosen to ignore the law because they know, or in the past they knew, that there will be no enforcement, so there was no downside to them. They just ignored the law, and you obeyed the law, and that was just your bad luck. They had an advantage over you. It's possible to take private legal action in those cases, and I will show you such a case towards the end of our presentation. And then we've got the Advertising Regulatory Board rulings, which, although it's called the Advertising Regulatory Board, is not actually regulatory. It's a private body. So these are the current issues, I think, on the table which have come up and that we need to just talk our way through today. So let's first talk about enforcement of R146, the Foodstuffs, Cosmetics and Disinfectants Act, under the Foodstuffs, Cosmetics and Disinfectants Act. So R146, as you will all know, are the so-called labeling and advertising regulations for foodstuffs. And in terms of the Foodstuffs Act, there are certain presumptions in there which make it much easier to prosecute offenders, as many technical defenses don't exist. So you will know that in litigation, people get away with things on the basis that some government official didn't fill a form in properly, or didn't send it in on time, or there was some technical legal issue not related to whether or not you actually comply with the regulations. Now, if you are prosecuted under the Foodstuffs, Cosmetics and Disinfectants Act, it's very difficult to rely on a defense such as, oh, but the form wasn't filled in on time, it wasn't sent to me on time. The prosecution, if it follows, is that you could have 6 months of imprisonment for a first offense, 12 months for a second offense, 24 months for a third offense, or of course the courts can fine you in the place of imprisonment. Now, historically, this has really not happened, but take my word for it, it's coming. the other very important part is that they can order the forfeiture of goods. Now, this is now starting to rear its head. So in the past, this was all theory. I would say to people, remember, your biggest hazard or your biggest danger as a company is there can be an order for you to destroy all your product which is non-compliant. And people would say to me, but that's impossible. In a country with so many hungry people, how can they order you to destroy your product? Well, it's in the Foodstuffs Cosmetic Disinfectants Act and in R146 that one of the remedies is if they take action against you, they can get an order ordering you to forfeit all your product. I suppose if you forfeit, you give it to the state. I suppose the state could give it out to the hungry or whatever, but they can order you to destroy it. Now, what's been happening since the lockdown that I've become aware of now on several occasions is Port Health has started refusing entry of product into South Africa, which is non-compliant at the time that the ship docks. Those of you in the import and retail industry will remember that what used to happen in the past was you would import your product, you would say to Port Health, if you were asked, don't worry, we're going to stick new stickers on it, and they will be compliant with South African law. We're just going to put it in our warehouse, we'll overstick it, and then it'll be compliant. Port Health has now invoked Regulation 2 of R146, which says that any foodstuff which is imported into the country must be compliant with R146. Doesn't say it must be made compliant with R146. So what Port Health has said, it's simply refusing entry into the country of the product when it arrives. A matter that somebody discussed with me, product produced in Germany, labeled only in German. The point was that when it gets to South Africa, it was going to be relabeled for resale in South Africa. They were told they can't bring it into the country. After much discussion and debate, they had agreed that the container that was already here would be allowed to be relabeled one last time, but no more. Unfortunately for this company, there were other containers that were already on ships on the water to South Africa. You can't turn the ship around. So when that container gets here, how will the Department of Health, Port Health, deal with this? Will they refuse it entry again, having said this is the last time, or will they be able to, on the basis of documents showing that it was shipped before that last discussion, be allowed to really one last time relabel it? But the point being is that anyone importing product into South Africa must ensure that the packaging complies with our requirements before it leaves the port in the country where it originates. You cannot rely on the fact that when it gets here, you will make it compliant. So that's a very important one, and you can just imagine the costs of this if your product is refused entry and has to be sent back or destroyed. Okay, let's talk about R638, which is also under the Foodstuffs Act, and it's the hygiene regulations. So the person in charge is criminally liable for non-compliance with R638. For example, trading without a certificate of acceptability of premises, or some hygiene infraction, having food getting contaminated, employees who are working outside the scope or without the proper PPE, etc., under R638. And the employer can be liable together with the person in charge if controls are not in place, but the person in charge is primarily liable. And the person in charge is the one whose name appears on the certificate of acceptability. I've got a case which I'm going to discuss a bit further below today, which deals, amongst other things, with non-compliance at R638 and the dire consequences. But under R638, there is provision for removal or suspension of your certificate of acceptability, which can result in the closure of premises. But of course, we mustn't forget, your premises shouldn't even open if you don't have a certificate of acceptability, and that is what one of the cases is I'm going to discuss today. Then we've got the Liquor Products Act and the Agricultural Product Standards Act, which both fall under the Department of Agriculture and provide for criminal prosecution, Under this law, if you are not compliant, they can issue search warrants, they can arrive at your premises, at your plant, at the shop, seize documents that show that there is non-compliance. And although Section 10 of the APS Act and Regulations provides for an appeal procedure for adverse decisions by DAF inspectors or assignees, there's a very short time to appeal. And if you're going to appeal, obviously it's quite a complicated process. What's important to note is that the appeal regulations were updated earlier this year. It could have been towards the end of last year with this lockdown, time flies. While you're on appeal, you may not sell your product. Previously, while you were on appeal, you could sell your product. So that has changed. But I think the most important thing that's happened of late is refusal of dispensations. So industry used to operate on the following principle. You sell a product, DAF inspector or assignee says your product is not compliant. You actually knew it was not compliant. You were just waiting for them. You then write to DAF, you say, oh, our product is not compliant. Here is our application for a dispensation. We have 500,000 cans of this in stock. We've got a year's worth of packaging. Give us a dispensation so we can use up our products and our packaging. And most of the time, unless there was a serious health issue or misrepresentation, you would be granted a dispensation. I have had to deal now with a couple of instances during lockdown where dispensation has simply been refused. We're not going to grant you dispensation. You know what the regulations say, you must comply with the regulations. Now this can have dire consequences, huge costs. And you need to think twice. You need to really have all your products labeling checked and rechecked before you launch a product, because you cannot rely on the fact that you will be granted a dispensation. It's very, very important. The other thing you need to know about a dispensation is that if you apply for a dispensation, you are admitting you are wrong. I have a client at the moment where the situation is as following. They launch a product, they then get issued a directive to stop selling the product. They then apply for a dispensation. The dispensation gets refused. Here's my dilemma. I can't appeal because in your dispensation, you admit your labeling is wrong. An appeal can only be on the basis that actually, no, the labeling is not wrong. Your interpretation of what the labeling should be differs from that of DAF, and therefore you file an appeal. But if you've already filed an application for dispensation wherein you say, our labeling is wrong, we have 500,000 packets, it will take us 6 months to sell it out, please grant us the allowance to sell it. If they refuse your dispensation, what are you appealing? You can't appeal the fact that you've already admitted your labeling is not compliant. Okay, so, and then of course you can get issued finally with a directive to cease sale of non-compliant product, and if you ignore the directive, you could be prosecuted criminally and fined. As regards the Liquor Products Act, I will actually speak about that later because there's a very interesting court case which came out in October. Then we've got the Consumer Protection Act. There we've got the Ombudsman for the Consumer Goods called the CGSO. There's a National Consumer Commission which will conduct an investigation, which can result in a National Consumer Tribunal hearing. If you are found guilty, it can be a fine of R1 million or 10% of turnover, whichever is greater. And there's the possibility of 12 months imprisonment instead of a fine. Now, the reason why the Consumer Protection Act is important is that the National Consumer Commission has taken a view on food safety, which by the way doesn't make sense, but that's irrelevant. They're roping in EHPs and arriving at businesses with police and trucks and want to seize and remove product which is after its best before date. Now, those of you that have attended previous webinars or followed this subject will know that it's in fact not illegal to sell a foodstuff after its best before date. And in fact, most food is perfectly safe and good quality after its best before date. But the National Consumer Commission cannot and will not be convinced of this. If the product is after its best before date, they believe you're committing a criminal offense and they arrive in force and want to remove your product. What you must never do is change or cover up a best before date, because that will result in real criminal prosecution. Because although it's not illegal to sell a foodstuff after its best before date, it is illegal to cover up or change a best before date on a product. Okay. And then we get to probably the strongest enforcement arm we have in South Africa, which is the National Regulator for Compulsory Standards. And non-compliance with SANS 289 or SANS 458 can lead to prosecution and fine and even forfeiture of a product. Now, SANS 289, those of you who don't know, is the one that says what letter sizes you have to have, whether you say it's grams or kilograms or milliliters, what spacing must be between the letters, etc. Now, the NRCS is very proactive in finding non-compliances. During lockdown, I had to deal with a couple of cases for people selling hand sanitizer, which was non-compliant with an NRCS standard. And yes, they are completely inflexible. Thou shalt comply. There is no debate. There is no dispensation. There is no allowance, officially anyway. They will assist you to apply for the registrations and so on. But if it takes 3 months to get a registration, it takes 3 months to get a registration. So the NRCS will issue a directive ordering immediate removal from sale. And if you fail to remove it immediately from sale, you are subject to criminal prosecution. I'm aware, for example, of a case a couple of years ago where 1 liter olive oil bottles were sold. And in terms of SANS 289, the letter size should be 6 millimeters. But the company that had printed the label obviously hadn't measured the actual label. They must have worked off a approval document or something. And the letter sizes were 5.5 millimeters. And over a difference of 0.5 millimeter, all the olive oil was ordered to be removed from sale and relabeled. So these are fairly serious consequences. Okay, where does the Advertising Regulatory Board of South Africa fit in? ARB. So ARB replaces the old Advertising Standards, ASA of South Advertising Standards, I forgot what the second A is for, of South Africa. They went bust. Yeah, they were liquidated. And the ARB was established in its place. Now, what one needs to understand is that both the SASA and the ARB are actually voluntary bodies. They are funded by their membership and only have authority over their membership. But what does that mean? So ARB is established by the marketing and communication industry. It's a self-regulation system. It's an independent body. It has an advertising code of practice. And in the general print, it's got general principles, and then it's got specific regulations in the appendices, one of which is for food and beverage. So the ARB can make decisions over food and beverage issues. There was one which was came out yesterday or the day before over Albany bread, which had a claim on the packaging that it was tamper-proof with a picture of a lock. And if I remember correctly, Premier, Blue Ribbon, lodged a complaint with the ARB that in fact this was misleading to the public because it wasn't tamper-proof. You could tamper with it. And the ARB ruled that they had to stop using that claim. So that's the type of things that go through the ARB. If it's something that falls under an act or a regulation, the ARB has no authority over that. That you have to take to the regulatory authority. And then if the ARB has ruled against you 3 times, thereafter you have to take all your advertising to them for pre-approval prior to launching. So that's the consequence. What are the opportunities and limits of this procedure? So if a consumer complains, it's free. If you're a competitor and you complain, you have to pay. It's a much simpler and shorter procedure than a court procedure, as you'll see from the cases I discuss a bit further along. But they can only consider matters provided for in the ARB code, and they cannot rule on legal non-compliance. They have no jurisdiction in technical matters and can only bind their own members. Now, what does only bind their own members mean? So if I'm not a member and my labeling, I make wild claims on my product, not claims related to things which fall under R146 or something, but other statements. Does that mean that I can do so with impunity? And the answer is no, because although it's only binding on their own members, there are many members, including through an imputed legal arrangement, all the broadcasters. So if they make a ruling against you, even though you don't have to comply with it because you're a non-member, your ads won't be flighted, the newspapers won't run your ads, and many retailers will stop selling your product. If you're only selling online to an online presence, you may shrug your shoulders and say, who cares? But that's what it is. Okay, so let's talk about R638 and the general hygiene requirements for food premises and the transport of food. So under R638, you may not handle food or permit food to be handled unless you have a valid certificate of acceptability. This also applies to vehicles. I've just put that in because it's a pet hate of mine. People don't seem to understand that vehicles also have to have a COA. But this is an important part. So the certificate, the COA you have, must be displayed in a conspicuous place on your food premises. And if that's impractical, you must immediately make it available on request. If the person in charge of food premises is replaced by another person, then within 30 days, you've got to get a new certificate in the name of the new person. Otherwise, your certificate will expire permanently. You must just note, they don't come and cancel your certificate. It simply expires on day 31 after the previous person whose name was on the certificate no longer works for you. You no longer have a COA. You should actually close your doors. And then, of course, no person may make any unauthorized changes or additions or forge a certificate of acceptability. I always laugh every time I read this, or forge a certificate. I'm so surprised that you have to state that you shouldn't forge a certificate. So the duties of a person in charge are here. I'm not going to go through them today, but you have certain responsibilities relating to training of staff, making sure that they are routinely assessed, that there's training programs, etc. Now, what are the powers of the inspectors? So now an inspector arrives and he wants to see your R638 certificate. What does that mean? So a person in charge may not handle food or allow food to be handled in a manner contrary to the provisions of these regulations. Now, the first provision is you must have a certificate of acceptability of premises. So if the inspector comes and you don't have that certificate, he can close you right there. And that's what the case is about that I'm going to get to. But even if you do have a certificate, the inspector arrives, he inspects your premises. And if they are of the opinion that the premises or facility or any activity constitute a health hazard, and that you continuing to operate will pose a health hazard to the public, they will prohibit you to continue operating. So they can prohibit you from operating if you don't have a COA, or if your operation actually poses a health hazard in their opinion. Please note, it's not a conclusive based on extensive testing, etc., etc. It's in the experience of the EHB, in their considered opinion, you pose a health hazard. And when considering all of these issues, the inspector should follow the guidelines A, B, C, D, and E. And then if having considered all of this, they believe that you should be closed, then the local authority may summarily prohibit the use of your food premises. They will hand you a prohibition notice, and that's it. You will close until you are compliant. Now, there was a case that came out in October 2020, and I thought this is why I went to R638 again. In the KwaZulu-Natal High Court, it ordered closure and vacation of a McDonald's premises in Kwadukuza for non-compliance. So, I mean, this is quite extreme, you must understand. They ordered the McDonald's to close, and then they ordered the premises to be vacated. Not just the people. Vacated means take all your equipment out. And the reasons for this judgment were that they didn't have a certificate of acceptability of premises, they had no occupational permit, and they had no business license. Now, clearly there's a problem here. I mean, how could this business operate without any permitting? I mean, I don't really understand it. I wasn't there. The court has spoken, and if the court has spoken and has said that they didn't have any of these things, they didn't have any of them. from my reading of the case, the municipality had approached them, had given them warnings, had given them notices. I don't know if I read the judgment correctly. The owner of the McDonald's took the view that he was going to get if he doesn't comply, it's only a 4,000 Rand fine. So he's happy to continue trading and pay the 4,000 Rand fine. But it didn't work out that way for him. The court ordered them to close and to vacate the premises and not serve any food until all permits have been obtained. From what I read, they reckon the damages are going to run into the millions because of this. The second case I want to talk about today is the Liquor Products Act. And this is a case that also came out in October. Now, this case went all the way to the Supreme Court of Appeal. So this case can't be appealed any further. I mean, I suppose theoretically it could go to the Constitutional Court, but I doubt it's a constitutional matter. So a company was selling whiskey-flavoured spirit aperitif, sold in Scottish-looking get-up and intended to draw whiskey drinkers through use of terms such as Highlands. You'll see when I show you the packaging in a minute what the intention of the people who produced this product was. But just think about this. So you make effectively a vodka, you flavor it as whiskey, you package it so it looks similar to whiskey, and you sell it next to the whiskey. So the Liquor Product Act prescribes composition of alcoholic beverages, including whiskey and the labeling thereof. So under the Liquor Products Act, just like you have under the Agricultural Product Standards Act, if you want to call something by a name, its composition must comply with the compositional requirements in the Liquor Products Act. Likewise, there are labeling requirements under the Liquor Products Act, and your product has to comply with the labeling requirements in order to be legally sold. Now, the way that the Liquor Product Act works is you submit your labels for pre-approval to the administrative officer. I suppose it's an equivalent of the executive officer under the Agricultural Product Standards Act. So you submit your labels to the administrative officer for approval. So quite obviously, if the product was actually on sale for a number of years, it had been approved by the administrative officer under the Liquor Products Act. And this is where one of the points on one of my early slides comes in, where I said that you can take private legal action for enforcement of law against a competitor. So what happened here? A competitor went to court on the basis of unlawful competition and taking advantage of non-enforcement. So the unlawful competition is this. I am a seller of whiskey. I have to comply with the whiskey specification, the whiskey labeling, and therefore my product is expensive. You do not comply for whatever reason with the requirements for whiskey. You sell a whiskey-like product at a much lower price than my product, and the effect is you are competing unlawfully with me. So that's an interesting concept. And how are you getting this right? You're getting this right because you're taking advantage of the fact that the Liquor Products Act administrative officer is not enforcing the act and regulations against this competitor. So what happened? The Supreme Court of Appeal, so the Supreme Court of Appeal is the highest court in the land. You go High Court, then Supreme Court of Appeal. The only court higher than the Supreme Court of Appeal is a constitutional court, but the Constitutional Court normally doesn't hear commercial matters. It normally only hears matters that have a constitutional angle to them. Okay, so the Supreme Court of Appeal ordered a halt to selling, offering for sale, promoting, marketing, or distributing products with the get-up and or labels like those of the products, in other words, the whiskey-flavoured spirit aperitif, using in any manner in the course of trade or otherwise the name or description whiskey, or any derivation thereof in relation to any product that does not satisfy the statutory requirements for whiskey. Representing a product to be whiskey or to have a connection to whiskey or to be in any manner related to whiskey when it is not so. Now, while I'm reading this to you, you must in your mind contextualize what other products this can apply to. So whenever you've had approval from an assignee or the Department of Agriculture of a product which should not have been approved, it doesn't mean that once approved, now it's legal. It still has to comply with the law. So if the assignee made a mistake and approved your product, it doesn't mean your product is legal. It just means that that particular assignee doesn't really know what the regulations are. It's a very important concept because Mr. Billy Makofola, when he was the executive officer of the Department of Agriculture, often said this, that regardless whether a label has been pre-approved by the Department of Agriculture, whether it complies with the law is a question of fact. You have to look at the law, not at whether an inspector had approved it. Okay. And by the way, you'll also be aware that the Department of Agriculture and the assignees have now stopped all approvals of labels. And I think it flows from this court case. Okay. And then the court ordered a halt to using in any manner in the course of trade or otherwise the word Scotch, Scotland, Scottish, or any other word or phrase which Scotch, Scotland, or Scottish is part of the labels and presentations, which includes insignia or any other representations evocative of Scottish origin in relation to any liquor product which has not been wholly manufactured or produced in Scotland. And this is why. So let's have a look at this. So if you walked into a supermarket or into a liquor store and you saw this on the shelf, would you think this is whiskey or would you think this is whiskey-flavoured vodka? It's called Royal Douglas. It's got those insignias on it. There's a King Arthur. The colors all look whiskey-like. The packaging looks whiskey-like. There's on the bottle double distilled. So yeah, if you look at this, and apparently the box that it came in, those that came in a box, also had a bit of a tartan design on it. So this is what the court looked at when it made all those prohibitions. So following from what they said, the Supreme Court of Appeal then ordered destruction of all product. You must know how many millions of rands of products you must be talking about. Destruction of all product. Destruction of all such packaging material. Halt to claiming an alcohol percentage which was not true. What also came out in this court case, which was very interesting, was that they were claiming 38% alcohol or 43% alcohol. The percentage escapes me. But when tested by a lab, the percentage was in fact much lower. The court ordered them to stop claiming that it's whiskey flavored. And actually, if you have some time, you should read this case. It's very interesting because they brought experts who gave evidence that you can't flavor something to taste like whiskey. Now, I beg to differ. And if there's anybody from the flavor industry in the audience, you may agree with me that surely you can flavor anything to taste like whiskey. But the court decided that nothing can be whiskey flavored. Only whiskey can be whiskey flavored. And then it ordered them finally to halt all advertising and to destroy all advertising material. So destroy all your product, destroy all your packaging material, stop making claims, destroy all your advertising. And then it said, if you don't do this in the next 20 days, I am hereby ordering the administrative officer under the Liquor Products Act to prosecute you criminally. So they were given a 20-day get out of jail free card. The judge could have said, and I order you to be prosecuted criminally, but he didn't. He gave them 20 days to give proof of all of this destruction, otherwise they must be prosecuted criminally. So, you know, if you just consider how this could impact on the food industry, this is really, really important. And as I say, in my practice, I do see from time to time labeling which people tell me has been approved by an assignee or approved by an inspector. They have a letter to show it's approved, but I can see it's not correct. And that's the end of my presentation for today. Thank you.
Thanks, Janusz. Thank you. It's very, very interesting. There's a few questions that I want to ask. Firstly, I just wanted to ask you if you want to read more about the whiskey case, because it's very interesting to me specifically. Where do we find this? Is there a specific article that we can link to?
It's not actually an article. It's a case from the Supreme Court of Appeal. I can email it to you. Otherwise, if you Google, I can't use my computer screen now because otherwise it'll take the thing that's off. What is the name of the company? I've forgotten what the name of the company was that was involved. You know what? I'll just email the case to you. It'll just be easier.
Okay, no problem. Just was interesting for me.
Because there's a website called SAFFLLI, which is a website where all court cases get posted, but you have to know the name of the case, so you might not find it.
Okay, good. Okay, I think the first question here is, I think we have spoken about it before, but just to rephrase it quickly. So the questioning is, where does the legal buck stop? Is it with or distinguish between the dealer brand, the manufacturer brand, and the licensor brand, or the licensor brand? So it's just who takes responsibility, I assume, is the question. But yeah, where does the legal buck stop between all the different brands?
In general, all of these laws say the following: that it's illegal to manufacture, distribute, sell, advertise products which don't comply with whichever act or regulation. Foodstuffs Act, Agricultural Product Standards Act, etc. They all say that, which means selling a product in your store which is not compliant, even a product you didn't make, is illegal. Now, because it's illegal to sell that product. It's also illegal for the person who sold you the product to sell the product. Now, when you look at that court case that I'm going to send you, Anza, you'll see that it wasn't just one company that was sued in court. It was to some extent the distribution channel. So the manufacturing arm, the distribution arm, they didn't sue retailers. They didn't go after Johnny's and Rebel and Tops. They didn't bother to go after those people. They went after the manufacturing and distribution arm. And in principle, that is probably what will happen, although at the very least, you'll be ordered to stop selling the product. I mean, I've seen retailers come to me with a directive: stop selling this mayonnaise, which doesn't comply with the regulations. And they don't make the mayonnaise, it's a national brand. And then we would send that directive upstream to the manufacturer and say, look, you've received this directive, we have to stop selling your mayonnaise. So theoretically, they could prosecute the retailer. I don't think we're there yet in our law, but certainly the importer, the manufacturer, distributor at that higher level, I think they will hold responsible. And it doesn't help to point fingers. You know, it's like somebody, I steal the car, I take the radio out, I sell the radio to someone, and he buys a stolen radio. So he's also liable because he's bought a stolen radio.
Good, thank you. Then the next question here relates to the R3638 regulation. So it's a practical question. It's just, if you've handed in your application for a change in person, but it's not been issued yet, does your certificate still then lapse on day 31?
Are you talking about when there's a change of person? So somebody's name was on the COA, and then the responsibility is to notify them. I think if you can show that you duly, properly notified them, they would have a great difficulty prosecuting you, and I don't believe that your certificate has expired. But you also have to show that you're following up. I don't know how many of you have seen that big court case about gun licenses. That there were people who were submitting applications for renewal of gun licenses which weren't getting renewed. And then their gun licenses lapsed. So they went to court, trying to say, well, it's all illegal. You can't lapse my gun license because I did apply for a renewal of the gun license. And the court was very hard. This went all the Constitutional Court. The court said, you can't just apply for something and sit back and wait. Now, I think it's quite hard. I mean, are you expected to go to the High Court and try and force the municipality to issue you a COA Maybe it comes to that. Let's wait. There may be court cases like that to follow. You know, if you look at this Quadrucusa case with the McDonald's, it was ordered to be shut down and vacated. Okay, in their case, I read the case, and it wasn't a matter of them having submitted documents and were waiting for them. That wasn't the case. That didn't seem to be from the court case. But if it was the case that they had submitted their documents, they weren't processed, and then they were ordered to close, then the next step would have been, if you submit your documents and they don't get processed, you have to go to the High Court to force them to process your documents. But I wouldn't go there yet. I wouldn't go there yet.
Yeah. Seems also that will be a lot of effort to do that, right? Another one, I think, just in terms of all the regulations that you mentioned today. So it's more in terms of during the COVID lockdown period and financial constraints, there's a lot of local markets and homemade foods. So the question is, how does all this regulation and legal standards impact local markets, homemade foods, people trying to generate income from making foods at home and selling them?
Look, once you start selling it, you're a commercial business. Everybody should follow the law and have a COA and so on. You know, practically, I don't think it's possible for them to enforce it. But the successful ones are going to grow. So if you're just making some food and selling it to your circle of friends, it's probably not going to no one's going to prosecute you. But once it really takes off and your biscuits are good and everybody wants them, you're going to cross that boundary where you're now no longer just this person making a few biscuits to sell to friends. And then you better make sure that you're complying with the law, because they can then come, well, they could come after you as soon as you start selling. But once you get big enough, it makes it worth their while to come after you.
Good. Yeah, I think it's also a question is how do you make them more aware of all these standards and regulation? Because if you just start making products, foods and cosmetics from home, you will not be aware of all of these. So I'm not sure if everybody is doing the homework before they start making these products and start to sell them. Yeah.
And Anza, some of the stuff could be outright dangerous.
Yes, exactly.
I mean, the reality is that not everybody understands food safety. You know, I remember doing a talk at a client to their supplier base. And when I started explaining this, there was a lady towards the back of the hall and she started crying. So we sort of stopped. What's going on? And it was like a taste naverate lady.
Yeah.
And she was making everything from home, with like the dog in the kitchen watching her cook, and you know, and I actually just said jokingly while I was talking. I mean, you know, I sort of said jokingly, you know, you can't just cook at home and every now and then your dog licks the plate type of thing. And then this woman burst into tears, which makes me think every now and then a dog does lick the plate. But the point is that yeah, it's difficult. People who'd never been in the food business wouldn't understand the hygiene issues and the food safety issues.
Yeah. Yes. Then just another one here on the point regarding incorrect interpretation of the LPA and the agriculture product standards. So what is the recourse for if assignees or the officials gets it wrong, technically?
So here's the problem. If you look at the Agricultural Product Standards Act and all of these laws, as long as the official acted in good faith, in other words, what they did was because they believed it to be correct, not because they got given some money to sign something off, or because they were malicious and didn't sign it off. If they did it, it's just an error. They thought it's right, but it's wrong. You've got no recourse against them, nothing. And it's unfortunate because you could have R1 million of packaging in your warehouse, which is suddenly not usable. Now, in the past where this has happened, I would get hold of the Department of Agriculture and I would say to them, look, my client went and produced this R1 million worth of packaging because the label was signed off. You need to allow my client to finish using their packaging. I haven't had one since they've had this new change of heart, where they're now turning down dispensations far more than they're granting them. So I would hope that logic will prevail, and if they actually approve the label, that they would allow you to sell out. But I must also add that for the last, I think, 6-7 months, they're not approving labels anymore. You know, DAF and assignees no longer approve labels. They say it's up to you to make sure your labels are right. Read the law, consult with whoever you got to consult, make sure your labels are right.
Good, thank you. Clear. There's a question on whether the slides will be available. So we are saving the, yeah, I think, but also the recording is on the SAFOST website, if I'm right, Tetsi. I think Tetsi is still on the line.
No, he did say that. He did say that, yes.
Okay, great. Janusz, then there's one on the ARB for if you had 3 rulings against you, how long do you need to send your advertisements and marketing material to them for pre-approval? Is there a time period attached to that?
You know what, I really can't remember. I've never had one. I've never had somebody that was like a persistent ignorer of rulings type of thing. I've never had one. So I don't know. There is definitely a period. It can't be forever. I really don't know. But ARB have a very nice website with a code. The whole code is available on their website. Actually, you can read up the rulings as they come out on their website. It's actually very interesting to read and an eye-opener. I would really highly recommend that you have a look at the ARB website. For example, as I said, with this tamper-proof packaging of the Albany bread was one of those cases.
Good. Thanks for that. Interesting one, and I'm going to omit some of the information. I'm not sure if you're going to be clear on the question, Janusz. So it's on a cider flavored maize-based beverage. So it's a maize-based beverage that's cider flavored. Is that compliant with the law? Or
but is it alcoholic or non-alcoholic?
It's alcoholic.
So it's a sorghum beer. No, it's what? Maize-based. No, so maize-based is like beer.
Yeah.
No, look, so there was a problem. I think it was SAB that made that product called Reds, which was actually a apple-flavored ale. And if I remember correctly, now just in the last couple of months, they were ordered to stop doing that.
Good.
So it could be a problem. The problem is that cider has a definition in the Liquor Products Act. So you can't say it's product B, but it's flavored as product A. I think that's the real issue if you read the Supreme Court case. You could probably say apple flavored, but I don't think you could say cider, because cider is a category within the Liquor Products Act. You know, I had a client with a product that's on the market, non-alcoholic gin and tonic, and they were ordered to change their name. They said they couldn't use the name gin because gin is a defined product.
I'm just trying to see quickly if there's more questions on the same issue, but I'm not picking it up. Good. I think I've asked most of the things now, Janusz. There's a few things that I'm trying to track here, just on not really specifically to the presentation, which I will ask separately to, and then we can respond to the attendees. So I think that's everything that I've got to track here on the questions section.
Great.
Good, thanks. I think there is a few more popping up, but maybe we can send that to you on email and we can respond directly to the attendees. So Janusz, thank you very much. This was very, very informative. It's always for me good to have a quick summary of all the regulations and standard in once, give you a big overview of everything again. But yeah, thank you much, like I said this morning, for taking the time. We know that you're quite busy. And thank you for making it so clear. I think there's a lot of things in terms of regulations and sometimes very complex to understand, but for me, every time that we listen to you have the knack to make it quite easy to understand and to follow what is wrong and what is right. So thank you for that.
I appreciate it. Thank you very much. Look, I must say, it's complex and it's getting more complex. As they update regulations, add more regulations, it gets more complex. And I try to keep it simple because you can't apply things if they're too complicated. That's part of the problem.
Yes, yes. Yeah, so thank you for making that a bit easier for us. Yeah, so have a good day, and thank you then for everybody that's joined us today. and we will make the recording available then on the SAFOST website. Thank you.
Thank you, everybody.